Somewhere in the vaults of the family division of the High Court of England and Wales, there is a document. It is the last will and testament of Queen Elizabeth II, a woman who reigned for 70 years, who accumulated assets, who made financial provisions for her family across 7 decades of sovereignty, and who, in her final years, watched her family fracture in ways that no British monarch in living memory had ever experienced. That document exists. It is real. It has been reviewed by judges, referenced in legal proceedings, and discussed in parliamentary debate. And it is sealed. Not for 5 years, not for a decade, not until the relevant parties have had a chance to sit around a table, reach some private family understanding, and agree on what the public is eventually permitted to know. Sealed for 90 years. The public, the people who funded the monarchy through the sovereign grant, through the Crown estate revenues that flow into the Treasury, through the constitutional framework that gives the royal family its extraordinary and uniquely privileged position in British life, will not be permitted to read that document until the year 2113. Most people alive today will not live to see it opened. Most of their children will not live to see it opened. We are talking about a generational lock on information that directly concerns one of the most powerful and scrutinized families in the world. And inside that sealed document, along with the financial provisions, the bequests, the distribution of assets accumulated across the longest reign in British history, are almost certainly provisions that directly affect 2 children currently growing up in Montecito, California. Archie Mountbatten Windsor, Lilibet Mountbatten Windsor, Harry's children. The grandchildren of the woman whose will they will never read. The great-grandchildren of a monarchy whose financial decisions about their future have been made in complete and permanent secrecy, in a legal framework their father cannot challenge, in a document their father will never see. Tonight we went inside the sealed room. We explain what is almost certainly inside it, why it matters, and why Harry, for all his lawyers, all his lawsuits, all his transatlantic campaigns for what he calls transparency and what the palace calls disruption, cannot do a single thing about it. If this is your first time here, this channel exists to give you what the polished royal correspondents and the palace-approved commentators will not give you. Forensic analysis, constitutional precision, the unfiltered mechanics of how this institution actually operates, behind the ceremony, behind the press releases, behind the careful management of public perception that the monarchy has spent centuries perfecting. If that is what you are here for, and I suspect it is, because you are still watching, hit that like button now, subscribe to this channel, and let us get into it. To understand why the sealing of royal wills is so significant and so deliberately impenetrable, you need to understand a legal framework that exists nowhere else in the democratic world. In England and Wales, when an ordinary person dies, their will enters probate. It becomes a public document. Anyone can walk into the probate registry and read it. The financial provisions, the bequests, the distribution of assets, all of it enters the public record. This transparency exists for good reasons that were established over centuries of legal development. It allows creditors to make claims against the estate. It allows beneficiaries to verify that their entitlements have been correctly administered. It allows the public and the courts to understand how wealth moves through society, who controls it, and on what terms. The royal family is exempt from this. Specifically, the president of the family division of the High Court has the authority to order royal wills sealed from public inspection. This power has been exercised consistently, without exception, for every senior royal who has died in modern times. You may not know the names of the judges who have made these decisions, because those decisions have themselves often been made in restricted proceedings. But the pattern is clear and the precedent is unbroken. The legal justification offered for this exemption is the protection of the dignity of the sovereign and the royal family. The practical effect, and I want you to sit with this, is the complete removal of royal inheritance from any form of public accountability whatsoever. In 2021, this practice was challenged not by Harry, who at that point had enough legal battles on his plate already, but by media organisations seeking access to the will of Prince Philip, Duke of Edinburgh, who had died that April. The High Court not only refused access, but took the extraordinary step of conducting the entire legal hearing in private. The arguments for and against sealing Philip's will, the legal reasoning, the constitutional debate, the competing claims of public interest and royal privacy were themselves sealed from public view. A secret hearing to decide whether to keep a secret. That is not a phrase I have reached for rhetorically. That is a factual description of what occurred in the legal system of a modern democracy. The court upheld the sealing. Philip's will is sealed. Then, in 2022, the same process was applied to Queen Elizabeth II's will. And in 2024, when media organizations and legal challengers renewed their arguments, pointing to the unprecedented public interest in the late Queen's estate, to the constitutional questions raised by the scale of royal financial secrecy, to the basic democratic principle that public figures operating on public money should be subject to public scrutiny, the court again refused to compel disclosure. 90 years. The decision is made. The door is closed. And behind it, in the sealed provisions of a woman who loved Harry, who watched him struggle, who by multiple credible accounts maintained a considerably more nuanced private view of his situation than the palace's public posture ever suggested, are financial decisions about his children's future that he will never be permitted to read. Now let us talk about what we do know, not from sealed documents, but from the visible, reported, documented financial decisions that King Charles has made regarding Harry and his family since ascending the throne in September 2022. Because here is the critical point. You do not need access to a sealed will to understand the direction of travel. The direction of travel is written in every institutional decision that has been publicly made. And those decisions, taken together, paint a picture that is striking in its consistency and remarkable in its completeness. Frogmore Cottage, reclaimed. Harry and Meghan's UK base, the property that the late Queen herself had given them, that they had renovated at considerable cost, that represented their foothold in British royal life, was taken back within months of Charles's accession. No extended negotiation, no period of reflection, a clean, swift reclamation that left the Sussexes without a British residence and signalled, with the clarity that institutions use when they wish to communicate something they cannot say directly, that the new reign was going to be different in ways that mattered. Security funding. Withdrawn and not restored, despite Harry's repeated and expensive legal challenges. The financial cost of providing royal protection in the United Kingdom, which Harry had explicitly offered to fund privately, out of his own pocket, asking only for the operational infrastructure and oversight that only the Metropolitan Police can provide, was denied not on financial grounds, but on operational and policy grounds. Grounds that, in practice, made Harry's visits to Britain logistically prohibitive for a private individual of his public profile. Consider what that means. A man who grew up inside the most protected family in Britain, who served in Afghanistan, who has been the subject of very real security threats, cannot visit his home country safely. Not because the threat has diminished, not because the money is unavailable, but because the institution decided, on policy grounds, that it would not extend the operational framework that would make safe visits possible. The sovereign grant financial support that had maintained Harry as a working royal, the staff costs, the operational budgets, the institutional infrastructure of royal life ended with his working royal status. That was, structurally speaking, expected. When you step back from the working royal roster, the financial support that came with that role ends. But the speed and the completeness of the disentanglement went beyond what many observers anticipated. The intention, whether or not it was explicitly stated anywhere in writing, was legible. Each of these decisions was legally defensible. Each was institutionally logical within the framework of the slimmed-down monarchy that Charles had long advocated for and was now, as king, implementing. Each was, in isolation, explicable. But together, and this is the forensic point I want you to hold in your mind, they constitute a systematic financial severance, not a falling out between family members who might one day be reconciled, a structural severance. the kind that is built into frameworks and documents and sealed provisions and legal architectures that outlast the individuals who created them. Now add to this picture the question of inheritance. The late Queen's will, sealed, inaccessible, locked away until 2113, almost certainly contains provisions for her grandchildren and great-grandchildren. Harry, as a grandson, would be expected to feature in those provisions. His children, as great-grandchildren of the late Queen, and bearing the Mountbatten-Windsor name, would be expected to feature in those provisions. But here is the crucial legal detail that changes the entire picture. And this is the detail that most royal commentators either do not understand or choose not to explain. Charles, as the executor of his mother's estate and as the reigning sovereign, has significant influence in ways that British inheritance law for private individuals would not permit over how royal estate provisions are implemented. The monarchy is not subject to the same inheritance laws as ordinary citizens in every respect. The sovereign has constitutional powers and legal immunities that create a degree of flexibility in how royal assets are managed and distributed that has no equivalent in private law. Sources familiar with royal estate law speaking without attribution, as everyone does when discussing royal finances, because the institutional culture of secrecy extends even to those whose job it is to understand and navigate it, suggests that the provisions Harry's children might have expected from their great-grandmother's estate may be subject to management decisions that substantially reduce their practical value. Not eliminated. Elimination would be too visible, too contestable, too easily framed as a punitive act against children who have made no choices of their own and can bear no responsibility for their parents' decisions. But managed, structured, delayed, placed in frameworks that give the institution control over the timing and conditions of any financial benefit, in ways that a private individual in the same position could never lawfully impose. And Harry, who cannot read the will, whose lawyers cannot access the sealed documents, whose children have no independent legal standing in the British courts to challenge financial decisions being made about their interests, has no mechanism to verify, challenge, or contest any of this. The sealed will is not just a secret. It is a financial instrument whose terms are known to everyone inside the institution, the lawyers, the private secretaries, the financial advisors, the senior courtiers who move between governments and royal households with the ease of people who exist in a world where the usual rules do not apply, except the people most directly affected by those terms. Here is where the financial picture of Harry's children's future becomes truly and bleakly stark. When Charles became king, William automatically became the Duke of Cornwall. He inherited the Duchy of Cornwall, an estate worth over £1 billion in assets that generates tens of millions of pounds in annual income for its holder. This is not a gift. It is not a decision. It is an automatic legal transfer that occurs the moment a new king accedes, passing the duchy to the heir apparent, without any requirement for a decision, a document, an agreement, or even an acknowledgement. The financial engine that funds the Prince of Wales's household, his staff, his operations, and his ability to function as a senior royal was transferred to William automatically, in law, without any choice being made. Harry received nothing equivalent. There is no equivalent provision. The British system of royal finances, which has been refined and concentrated over centuries to ensure that hereditary wealth flows with maximum efficiency down the direct line of succession, has no structural mechanism for providing a comparable financial foundation to a non-heir. This is not new. It was not designed to harm Harry specifically. It is not a decision that Charles made against Harry. It is the architecture of royal inheritance as it has existed for centuries, and it operates with the impersonal precision of a legal mechanism that does not require malice to produce devastating outcomes. But in the context of everything else, the Frogmore reclamation, the security withdrawal, the slimmed-down monarchy, the sealed will, the systematic financial disentanglement, it means that Harry's children are growing up in a world where the financial infrastructure of their royal heritage is, systematically and structurally, simply not available to them. Prince George will be a very wealthy future king. His financial foundation through the Duchy of Cornwall inheritance, through the sovereign grant, through the full constitutional weight of the hereditary monarchy's resources, is already being built, stone by stone, duchy by duchy, provision by provision. Archie and Lilibet have their parents' Netflix deal, their parents' lifestyle brand, their parents' memoir royalties, and a sealed will they cannot read. Now add one more dimension to this picture, perhaps the most significant of all. Charles, who has been receiving treatment for cancer, who has watched his family fracture in ways that no monarch in modern history has experienced publicly, who has made financial and institutional decisions about Harry's family that carry the unmistakable character of a man who has decided which direction he is building. Charles is writing the document that will determine what, if anything, he leaves to his younger son and his grandchildren in California. That document will also be sealed for 90 years. Royal sources suggest, carefully, without the kind of specificity that would allow any of this to be directly contested, that Charles's will reflects his vision of the monarchy's future, that it prioritizes the direct line of succession with the same architectural clarity that his slimmed-down vision brought to the working royal roster. What that means for Harry's children, in precise, concrete financial terms, is something that will not be publicly known until 2115 at the earliest, by which point Archie and Lilibet will themselves be elderly. The monarchy will be on its fourth or fifth reign beyond the one that made these decisions. The world that sealed these documents will be history, and the people who made the decisions, Charles, William, the courtiers, the lawyers, the judges, will all be gone. This is the mechanism. And I want you to understand, it is not a conspiracy, because it is not a conspiracy. Conspiracies require secrecy and coordination in defiance of established rules. What we are describing here is the opposite. It is the established rules themselves. The sealing of royal wills is legal. The concentration of royal financial resources in the direct line of succession is legal. The management of royal estate provisions by the executor is legal. The denial of Harry's security requests on policy grounds is legal. Every single element of what has happened to Harry's family financially is legal, which is precisely what makes it so significant, because it means it cannot be challenged. You cannot challenge a legal framework through the courts when the courts themselves are part of the framework. You cannot contest a sealed will when the sealing order is itself legally unimpeachable. You cannot demand transparency from an institution whose exemption from transparency is itself written into law. Harry has understood this, slowly, painfully, publicly, over the course of years that have cost him an extraordinary amount, personally, professionally, and financially. The legal battles in British courts, the appeals, the partial victories that were reversed or rendered functionally meaningless by institutional intransigence. The memoir, the documentary, the Oprah interview. All of it represents a man trying to find a lever that works against a machine that was specifically designed over centuries to have no levers accessible from the outside. And what he has discovered, that this story demonstrates with forensic clarity, is that the machine was built correctly. The levers are inside, and he is outside. Let us be precise about what this means in its longest possible view. Archie Mountbatten Windsor is a prince. His title was confirmed when Charles became king, an automatic elevation under letters patent that Charles did not block. Perhaps because blocking it would have been too overtly hostile to children who could not reasonably be held responsible for their parents' choices. Perhaps because the letters patent themselves made blocking impractical. Perhaps I raise this only as a possibility, because in royal matters one must be rigorous about the distinction between what we know and what we infer, because the title costs the institution nothing while providing a veneer of continued inclusion that is institutionally useful. He is a British prince, growing up in America. With no British residence, no British security provision, no British institutional infrastructure, and no access to the financial provisions that his great-grandmother may or may not have made for him in a document that will be sealed until he is in his 90s. His sister Lilibet named for the great-grandmother she barely knew. The woman whose reign defined an era, whose face appeared on the currency of nations across the world, who by all accounts possessed a private warmth toward Harry that the institution around her sometimes complicated the expression of in precisely the same position. They are royals in name, they are private citizens in practice. And the decisions that determined that outcome, the will provisions, the financial structures, the institutional architectures, the legal frameworks, were made by people who will all be long gone before those decisions become publicly readable. This is the monarchy's ultimate power. Not the ceremony at Westminster Abbey, not the magnificent buildings or the crown jewels or the constitutional authority over the appointment of prime ministers. The monarchy's ultimate power is the power of time. The power of an institution that operates on timescales that no individual, not Harry, not Meghan, not even William himself, can fully contest or outlast. Because by the time the sealed documents open, by the time the full picture of what was decided and when and by whom and in whose interests becomes available to the public record, everyone involved will be history. And the monarchy, that extraordinary, infuriating, resilient, deeply and sometimes bafflingly human institution, will still be there, operating, managing, sealing, and writing the next chapter that none of us will live to read. What I want you to sit with, and I mean genuinely sit with, not as a rhetorical flourish, but as a serious constitutional question, is this. Should the children of senior royals, regardless of what their parents have done, regardless of the choices their parents made and the consequences those choices carried, have a legal right to know what financial provisions have been made for them? Is there a point at which the monarchy's right to secrecy, a right that exists nowhere else in British law, that would be inconceivable in any other public institution, extends too far? When it reaches into the financial futures of children who were born into this family, who carry its name, who bear its titles, who had no agency in the decisions that shaped their circumstances. I am not telling you what to think. This channel does not tell you what to think. What this channel does is give you the full, forensic, unfiltered information that allows you to think clearly and independently about what you are watching. Archie and Lilibet did not choose to be born into the House of Windsor. They did not choose to grow up in California. They did not choose to have their parents' marriage become one of the most publicly contested royal events in modern history. They are children, and the financial decisions that will define their relationship to the institution they were born into are being made in documents they will never read, by people they may barely remember, in a legal framework that was designed long before they existed and will endure long after everyone reading this is gone. That is the story. That is what the 90-year seal actually means when you trace it all the way to its human consequences. Not an abstract legal curiosity. Not a footnote in constitutional law. 2 children in California sunshine, carrying a prince's title, with a sealed vault in England that contains their financial future, and a legal system that has decided, with the full weight of precedent and institutional authority behind it, that they have no right to know what is inside it. Tell me in the comments what you think. Tell me where you stand. Tell me whether you think the sealing of royal wills is a legitimate protection of the institution or an abuse of the institution's unique legal position to avoid the accountability that every other family in Britain must accept. That comment section is going to be one of the most important conversations this channel has ever generated, and I genuinely mean that. Subscribe now if you are not already subscribed. This series is building towards something, and every topic connects, and you need the full picture to understand what we are ultimately looking at. Like this video if the forensic detail is giving you clarity that you are not finding anywhere else in royal commentary. And write next in the comments because topics 13 and 14 are the ones that would make palace lawyers genuinely uncomfortable if they knew we were this close to publishing them. The vault is sealed, but this channel is open, and we are just getting started.